Welcome to the deep dive. Today we're tackling something that, well, it feels a bit off, doesn't it? That moment when you realize the contract you thought you made online isn't quite the final word. We're diving deep into this common scenario. You order something, maybe a computer, over the phone or web. You pay right away. But then, the actual terms and conditions, they show up later, hidden inside the box with the product. So the big question for you is, when is that deal really sealed? Can those terms you haven't even read, like an arbitration clause, actually bind you just because you didn't return the thing? Okay, let's unpack this.
Right. And we're going to chart a clear path through this. First, we'll lay out the general rule for these terms-in-the-box situations, drawing heavily on a key case, Pro CD. Then we'll really put that rule to the test using the famous Hill v. Gateway 2000 case, applying that Fire Act method. You might remember facts, issue, rule, analysis, conclusion. We'll even push the boundaries with a memorable hypothetical. And finally, we'll synthesize it all into a practical checklist for spotting these issues. Because, knowledge is best when you can actually use it.
Okay, let's start right there with that basic intuition. I call Gateway, I order a computer, I give my credit card number. That feels like a done deal, right? A contract. How can Gateway, or any company, then just slide in extra terms later that we never discussed?
That's the exact conflict the courts had to grapple with, especially as mass market sales took off. The general rule, really cemented by the Seventh Circuit in Pro CD v. Zeidenberg, is that, the contract isn't always formed the instant you pay. Instead, think of the vendor as the master of the offer. They get to structure the deal. So that phone order, it might just be step one. The actual offer, the one with all the terms, might only be considered complete when the product arrives with those terms. And crucially, those terms become binding if you keep and use the product after you've had a reasonable chance to read them, and importantly, reject them by sending the product back.
Okay. I see the efficiency argument for the vendor. But doesn't that acceptance by keeping thing feel like it shifts all the burden? Suddenly I have to unpack everything, maybe even set it up, find the terms, realize they're not great, and then pack it all back up just because they didn't show me the full deal up front.
That is absolutely a central criticism of this doctrine, and yeah, it's why these cases got so much attention. The court in Pro CD didn't ignore that, but ultimately their focus was on, let's say, the practical side, the overall cost savings for consumers as a group. Their reasoning was basically about efficiency. They argued it's just too costly and, frankly, ineffective for someone, a cashier, a voice on the phone, to read out pages of legalese. They even called oral recitation ineffectual, basically saying nobody would really listen or absorb it anyway. So this approve-or-return approach, while maybe burdensome for an individual in some cases, was seen as reducing vendor costs, which theoretically leads to lower prices for everyone. The court's view was, if you get a clear chance to read and return, you've had fair notice.
Right, fair notice, even if it's after payment. That definitely raises the stakes. So let's take that rule, retention equals acceptance, and see how it played out in Hill v. Gateway 2000. Let's analyze Hill v. Gateway 2000. First, what are the legally dispositive facts?
Okay, the key facts are pretty straightforward. Rich and Enza Hill ordered a Gateway computer. They did it over the phone, paid by credit card. The computer arrived, and inside the box was a document listing Gateway's standard terms and conditions. Among those terms was a big one, an arbitration clause. This clause said any disputes had to go to arbitration, not court. And crucially, the document stated these terms governed unless the Hills returned the computer within 30 days. They kept it longer than 30 days. Then later, they sued Gateway in federal court with some serious allegations.
Okay, and what was the core legal issue the court had to decide?
The absolute core issue was, did that arbitration clause, the one inside the box, become part of a legally binding contract simply because the Hills kept the computer for more than 30 days, even though they paid up front and might have thought the deal was done then?
Got it. What rule or rules did the court apply to resolve this?
They applied two main legal principles. First, that contract law rule we got from Pro CD. Terms that come with a product bind you if you accept by conduct, meaning you keep the product after having a chance to review and return. Second, and this is really important, they brought in the Federal Arbitration Act, the FAA. The FAA basically says arbitration agreements are strongly favored and must be enforced unless you can find grounds to revoke the entire contract, things like proving fraud or duress. What the FAA doesn't require is that an arbitration clause needs special highlighting or prominence. Its enforceability comes from the act itself, as long as the contract overall is valid.
The FAA angle is powerful. So even if it was buried in fine print, it doesn't automatically make it invalid.
Yeah.
Okay, what was the court's analysis? How did they reason through it?
Their analysis hit a few key points. First, they flatly rejected the Hills' argument that the contract was formed and finished the moment they paid. They doubled down on the pro-CD idea. Acceptance happened through the Hill's action, or rather, their inaction, keeping the computer beyond the 30-day review period when they could have returned it after seeing the terms. Second, the Hills tried to frame it differently. They argued maybe this was a battle of the forms situation under the Uniform Commercial Code, specifically Section 2207. That section deals with conflicting terms sent between parties. But the courts shut that down. They said, look, 2207 is irrelevant here. There weren't two competing sets of terms. There was only one set gateways provided after the initial order. The issue wasn't conflicting additional terms. It was about whether a contract, including gateways terms, was formed at all.
Okay, that distinction makes sense. It wasn't a negotiation with back-and-forth forms.
Exactly. And third, the court tackled the idea that maybe the contract was already performed or executed once Gateway delivered the computer, meaning later terms couldn't apply. The court disagreed strongly there, too. They pointed out that Gateway still had ongoing obligations under those very terms about them. Think about the warranty or the promise of lifetime service support. Since Gateway was still bound long-term, the Hills, by keeping the machine, were bound to the whole document, including that arbitration clause.
Right. The ongoing parts tied both sides to the full agreement. And the conclusion. What was the final outcome?
The conclusion was clear-cut. By keeping the computer past the 30-day return window, the Hills had legally accepted Gateway's offer as presented, including the arbitration clause. Therefore, the appeals court overturned the lower court's decision. The Hills couldn't sue in federal court. They had to take their complaints to an arbitrator, as the contract dictated.
Wow, that is a landmark decision with huge implications for consumers. Okay, let's really stress test this rule now. Let's use let's say a more memorable hypothetical. Imagine you splurge on a super high-end espresso machine, maybe $5,000. It arrives, you're excited, you start using it right away. Tucked away inside, maybe under the foam packaging, is this little card. It says, by keeping this machine for more than 14 days, you agree your firstborn child must be named after our CEO, Bartholomew. You love the coffee, keep it for 15 days. What jumps out at you here, legally speaking?
Okay, Bartholomew it is. Well, maybe not. What jumps out is that crucial distinction we talked about. Contract formation versus enforceability or revocation. Under the strict Hill formation rule, because you kept the machine past day 14 after having the opportunity to find and read that card, you performed the acceptance conduct. So technically, that bizarre naming term was incorporated into the contract when it formed. But, and this is a huge but, just because it's in the formed contract doesn't mean a court will enforce it. That specific term is almost certainly going to be thrown out later if challenged. Why? On grounds of public policy, or perhaps unconscionability, meaning it's just so utterly one-sided and shocking to the conscience that enforcing it would be wrong. Remember, the Hills argued the arbitration clause wasn't prominent. The court basically said contracts don't have to be read to be effective. You accept the risk of unwelcome terms by not reading and returning, but that doesn't stop you from challenging a specific term later as being fundamentally unfair or against public policy.
Okay, so the takeaway is, keeping the product seals the deal, including all the terms, read or unread. You've accepted the package, warts and all. But you might still be able to fight specific outrageous terms later on different grounds, like unconscionability. The formation itself, though, happened when you didn't return it.
Precisely. And if we zoom out, this whole line of reasoning gives us a really useful diagnostic tool, a kind of checklist for you when you encounter these situations. This isn't just a summary, it's an actionable framework. So here's a 5-step checklist based on Pro-CD and Hill. Step 1. What kind of transaction is it? Are we talking about a sale of goods where the full terms arrive after you've already paid, usually inside the box? If yes, ding, 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 Pro-CD and Hill are likely relevant. Step 2. Is it just one set of terms? Did these terms come only from the seller after your order? If yes, then forget about the complexities of UCC 2207, the battle of the forms. That's not what's happening here. It's about formation based on this set of terms. Step 3. How did the vendor frame acceptance? Did the seller clearly state that keeping the product beyond a certain period means you accept the enclosed terms? Was there a defined approve or return window, like Gateway's 30 days? That invitation structure is key. Step 4, what did the customer do? Did you, the customer, actually keep the product past that deadline after having the chance, even if you didn't take it, to inspect the terms? If yes, under Hill, that conduct counts as acceptance. The contract, including those terms, is formed. Step 5, any way to avoid the whole thing. Finally, even if formed, are there grounds like fraud, serious duress, or maybe overall unconscionability that would allow a court to invalidate the entire contract? If not, then the terms, especially federally favored ones like arbitration clauses, are generally enforceable even if you never read them.
That framework really clarifies it. Payment isn't the trigger. Your conduct after receiving the terms is. It provides a vital shortcut for understanding your rights and obligations in so many modern transactions. And maybe a final thought to leave you with, something the court actually mentioned in Hill. The Hills apparently never argued that Gateway would have refused to send the terms beforehand if they'd just asked. So it raises this interesting question for you. If you know complex terms are probably coming later with the product, how much responsibility do you have to proactively ask for them before you click buy or place that phone order if you want to avoid being surprised by something like an arbitration clause, something to mull over?